Muchas gracias a todos por la organización. De hecho, bienvenidos a este panel de discusión que ya cierra con broche de oro las charlas que hemos tenido el día de hoy. Yo creo que todas las participaciones de verdad han estado increíbles y seguro con lo que viene ahora vamos a terminar de sorprenderles y abrirles la cabeza en lo que se refiere a la transformación de nuestra profesión y más particularmente el tema del día de hoy, que ha sido la transformación del sistema de administración de justicia. Antes de empezar, muchísimas gracias a la UP, a José María, a Cecilia, a Pipe Gamboa y a todos los organizadores que hicieron posible este evento y por supuesto, pues gracias por la amable invitación. Para esta conversación final, vamos a tener una invitada de honor desde Canadá, que es Shannon, directora en el Tribunal de Resolución Civil canadiense, el CRT, como estaba contando ahorita José precisamente, que es el primer tribunal en este país en funcionar 100% online y uno de los primeros en el mundo en esta modalidad, ¿no? Dado que Shannon nos acompaña desde Canadá, a partir de este momento pasaré a hablar en inglés y desarrollaremos el panel en este idioma. Recuerden entonces darle clic a este botón de intérprete simultáneo para las personas que quieran escuchar la charla pues en español con el intérprete, ¿no? So with this said, and before Shannon's intro and presentation, let me say hi and thank you to all attendees that join us today. Introducing myself very quickly to start with the true start of the panel. My name is Daniel Acevedo Sanchez. I'm currently Senior Manager at EY Law, the legal services arm of EY, the multinational consultancy firm. And I'm responsible for leading the legal operations services practice group for Latin America North and general terms speaking for the Spanish-speaking jurisdictions in LATAM. In the legal operations services practice group, we help mainly in-house legal teams and public organizations to transform their legal function operating model via process architecture identification, optimization, technology, developing and implementations, legal design, and more broadly, whatever we have in our toolbox to help lawyers to be more effective in their work. I'm a lawyer by training, but because of life goals, sometimes I have a master's degree in engineering and my postgraduate studies are heavily focused in systems design, technology strategy processes, and project management. Just to let you know, as Kat was saying earlier tonight, that lawyers can and should teach themselves how to be better attorneys by learning things outside the law. So, Shannon, welcome to Los Abogados del Futuro, tomorrow's lawyers, and thank you for being here with us tonight. I was thinking reading your bio, but I think that is a better idea because I don't want to miss an important point of your great career on the world of innovation in access to justice. If you introduce yourself and tell us about the amazing work you guys are doing in the Civil Resolution Tribunal, the CRT in Canada. The audience is yours, Shannon.
Well, thank you very much, Daniel, and hola a todos. It's a real pleasure to be able to join you this evening and tell you a little bit about our work. I'm relieved you didn't really read my bio. It always makes me feel a little uncomfortable. And so I'll just quickly say that I am a lawyer by training. I have a master's in law from the University of Toronto here. And I worked as a lawyer for a few years before becoming essentially a judge, a tribunal member with administrative tribunals, which are part of the public justice system, which led me to eventually chairing the Civil Resolution Tribunal, which I'll tell you about tonight. I'm also a part-time professor, and I've sat on a number of different tribunals and boards, and I write a lot about those kinds of things, as well as professional regulation of lawyers, which is one of the subjects I teach here in British Columbia. So I'm really grateful that we've got interpretation, and please, to our interpreters, please let me know to slow down if I'm speaking too quickly. I'm excited to hear your thoughts about this and your considerations about whether or not something like an online dispute resolution platform could work in Peru or in the countries from which you are participating. I had the great pleasure to visit Chile and Argentina late last year before the world completely imploded. And it was a real delight to be able to work with some members of the judiciary and the Ministry of Justice in Chile down there as well. And I very much miss your continent. So Again, a pleasure to participate tonight. So I'll start by sharing my screen, and hopefully this will work. Great. And Daniel, maybe you can give me a thumbs up if you can see my screen.
Yep.
Yep. Okay, great. So I'll start by asking a question that I get asked a lot these days, which is, with the pandemic, are we moving to online courts? Are online courts going to save our public justice system? And something that I've been thinking about a lot and talking about now a lot is this idea that online courts by themselves do not necessarily translate into having access to justice or having an egalitarian or equitable public justice system. And so the way I think to think about this is to think about that blue arrow being the status quo before March of this year. So before March of this year, there are public justice systems in most of the places around the world that I've traveled are all very much based on bricks and mortar, on somebody who has a dispute, having to take time off work, arrange for childcare, possibly hire a lawyer, travel down to a courthouse, and then navigate a process that was really not designed for them. It was mostly designed by lawyers and judges for lawyers and judges. So that's basically the way our justice system has worked around the world for hundreds and hundreds of years. Nothing magically changed with the pandemic, except that because of urgency, a lot of court systems around the world had to do what they were already doing, but do it via remote hearings. And so what you saw, I think, during that time is courts scrambling to hold hearings in the way that they always have, but just using Zoom. Courts using the same forms that they've always used before, but allowing people to email them back in. Courts using the same interfaces and websites that they've always had, and not really much has changed there. And so the worry is that because the tendency is to move very, very slowly in this area, that what we're going to end up with after the pandemic is over is not much better than what we had before the pandemic. And before the pandemic, what we had was really a global access to justice crisis, something that Richard Susskind talks a lot about, and frankly, that people talk about everywhere in the world that I travel. Instead, I think what the pandemic represents is a huge opportunity to do something fundamentally different, to actually redesign our legal system, fundamentally change the culture and the systems by which it operates, and redesign it around the needs of the most heavily vulnerable people in our society using human-centered design. And Daniel, I heard you talk about being an expert in system design, so I imagine this might appeal to you as well. And this opportunity is difficult, right? It's much easier to take the court process that you've always had and put it on Zoom. But there's some good work out of the United Kingdom and other jurisdictions that shows that remote hearings using traditional justice processes actually add a layer of difficulty for people and actually add extra barriers to accessing the justice system. But doing that is so much easier than fundamentally transforming the system from the foundations up. But it is possible. And so what I hope you'll get out of this presentation is a bit of a call to action, that if we are actors in the system, if we are the lawyers and the judges, we shouldn't settle for a future that just takes our system and puts it on a Zoom call. Instead, we need to do the really difficult structural work to change the system from within. But I'm hoping that you'll also take from my talk this idea that this is possible. And it's not to suggest that the Civil Resolution Tribunal is perfect or the model to be followed by every part of the justice system around the world. It's absolutely not. But it is an example of what can happen if you use design thinking, human-centered design, and a real commitment to empirical research in designing a very new part of the justice system. And I think it is true, as different as our justice systems are around the world, as different as criminal matters are from civil matters, that no part of the justice system would not benefit from having a careful re-examination, from us critically asking ourselves questions about why we do the things that we do. So I'll start with telling you a little bit about the Civil Resolution Tribunal, which is like an administrative court in the United States. My understanding is that there are similar tribunals in other parts of the world as well. But tribunals are like courts in the sense that they are part of the public justice system. And we are a very new part of the public justice system. We did not exist before 2016 when we opened our doors. So we're only about 4 years old. And we were the first online tribunal in Canada. But as you've heard me say, I don't think the solution to our access to justice problems is technology. Technology by itself does not increase access to justice. Instead, our goal is to do something much more profound, which is to take this little corner of the justice system that the government has given us responsibility for and bring it to people and build it around the realities of their lives. And so I'll tell you a little bit about how it is that we do that. We have jurisdiction over a very wide variety of civil disputes, everything from neighbor disputes in apartment buildings to small claims disputes, which usually involve small amounts of money that people owe each other, or things that they bought that don't work and they want a refund, those kinds of everyday legal problems. We also have jurisdiction now over most car accident disputes as well. And so what you can see is that the government in British Columbia first gave us jurisdiction over a very small little area, and then that increased year after year over the last 4 years as we learned more and built on our successes. All of our disputes go through the same rough process though, which is very focused on collaborative dispute resolution. It's focused on self-help tools and giving people free legal information. It's not focused on the judge role. I'm a tribunal member as chair, and there are a number of other tribunal members, but we're at the end, and we are the last resort. And when you file a dispute at the CRT, there is no assumption that you're going to end up in front of a tribunal member like me. Instead, we assume that with the right help and support, we can help you solve your problems so you can get on with your life, and we can empower you to be an active participant in that resolution. So this is a really important difference from the way that most civil justice systems are built. In most civil justice systems, you file your paperwork and you hope that at some point, maybe years later, you might end up in front of a judge. And all the steps you have to take along the way are usually geared towards that assumption that you'll go to trial. In most justice systems, though, that's not the case, and most cases do not go to trial. So what we've tried to do here is use empirical research that says only 2% of filed cases get to trial, so we shouldn't build the whole system around the judge or around the trial. And that's what we've done here. And it's worked out because overall, the vast majority of disputes settle early, sometimes with help. Only a very small number actually go to a tribunal member. So the first step is to get this free legal information through an expert system, which I'll show you. If people can, we give people tools to be able to solve the problem on their own if they can. If they can't do that, they can apply for dispute resolution. We serve the other side, so we give the notice to the other person in the dispute. And then when that person comes back into the process, the parties have a chance to negotiate, which looks mostly like WhatsApp or Facebook Messenger. It's a very easy to use chat platform. If that doesn't work, then a mediator steps in, looks at where the parties are and helps them work out an agreement if they can. These agreements are binding on the parties. They're enforceable as court orders. If all else fails, then the parties exchange their evidence and their arguments, and a tribunal member is assigned to decide the dispute. And their decision is usually emailed to the parties and also uploaded as a decision on our national database and also on our webpage. So you can do all of these steps from your smartphone. And in fact, that's what 99.9% of people choose to do. But Human-centered design requires that we also account for people who cannot access technology or who don't understand something. And so we offer a telephone service, mail service, before the pandemic, also in-person service, very flexible approaches. So this is an example of how technology is not the goal. Technology is one important tool in this toolkit. It is an outcome. It's an outcome of design thinking. But design thinking also leads to other outcomes, like the fact that for some people, there will be no substitute for in-person help, and we have to figure out how to get that to them. There'll be no substitute for having a friend or a family member assist them, and we have to make that easy. There will be no substitute for talking to somebody on the phone and having an interpreter interpret that for them. So human-centered design requires us to account for everybody, especially because we're part of the public justice system, and we can't let anybody fall through the cracks. This is what the website looks like and what it looks like on a phone. It doesn't require any apps because downloading an app itself is an access to justice barrier. One of the most important things I think we do at the tribunal really has nothing to do with technology and could be used pretty easily by any court in the world, and that's using plain language, natural language. We write everything about the reading level of an average 10-year-old, which is the average reading level in Canada. And we audit that using readability tools to make sure that's the case. So everything that the public sees, if it's an email from us or a letter from us, any information on our website, all the way to the actual court decision has to be written at the reading level of a 10-year-old. And because of that, I think the information seems a lot more inviting and accessible. People don't feel like they're stupid or they don't belong. Our whole goal is to make it seem like a very accessible, respectful process for them. So the first stage before somebody files a dispute is the Solution Explorer, which gives them free legal information and tools to resolve their dispute on their own, but also find more legal information without a lawyer, because people can't afford a lawyer for most of the disputes that we have jurisdiction over. So we give them information about our jurisdiction. We ask for feedback right here and on this not helpful button. And then we can also ask people what they want to do with the information. So this is just to give you a flavor. If you're interested, you can go to our website and take a look. It's obviously a lot longer than this, but the idea is that we ask people questions. We use their answers to be able to give them really targeted pieces of plain language legal information. And once we've given them enough information, we can ask them what they want to do about their legal problem. So in this case, we're asking if they want to go back to their insurance company and make a counter settlement offer. Do they want to get legal advice, or do they want to start a claim with the tribunal? One of the most popular tools that we have is a letter that's already written. It's based on the information people have already given us in response to the questions we've asked them. And people can fill this out from their phone. They just have to enter their own details. They can email it to somebody else. They can print it or download it. They don't need any software. It's really, really, really popular because this is the kind of letter people often hire a lawyer to write, and they can't afford to do that mostly. If people continue though in the process, then they reach this application page. Most of the time people get that letter and they go. And that's great because we know it's less expensive for people and probably going to lead to a better outcome if they can negotiate directly. Oftentimes people can't though, and that's when they fill out our application form, again from their phone if they want to, or on paper. And it's really basic. The reason it's so basic is because we design it with community legal advocates. Who are the community legal advocates? Well, they are the people in our province who represent those who have the most difficulty accessing our system. So they represent people who don't speak English as a first language, people with physical disabilities, people with mental health issues, people with a low income, people who live in very remote areas of our province, or some combination of those circumstances as well. So we design the tribunal in partnership with those advocates who will tell us, you know, my client won't understand the way a question is put here. Can you change it? And in real time, we make all of our changes in response to their feedback. And that's really important because in my experience, you cannot have a justice reform project that is driven by lawyers and judges as the advisory group. I see this happen a lot of times in countries around the world where there will be a decision to have a court pilot project for online dispute resolution. And the people implementing the project and advising on the project are all lawyers, judges, and court administrators. And they say to themselves, well, that's okay. We'll design it like this, and then we'll test it later. Or we'll scale it up or down to work for different groups of people. You can't do that. It won't work. If you design a system that was designed, or if you try to change a system that was created for lawyers and judges, and the people you call upon to do that work are lawyers and judges, you're going to end up with what you have now. It is a fundamentally different process to design for really vulnerable people. It's a very different way of thinking. It's a very different way of prioritizing things. It's a very different way of designing. But to do that work in partnership with community legal advocates, to do this work in partnership with the public, it requires us as lawyers and judges to admit that we're not the experts in that we are the experts in the law, but we're not the experts in every human being's lived reality, in the kinds of obstacles and challenges that everyday people have. They're the experts. And so it does require a lot of curiosity, a lot of humility to do it this way. And curiosity, listening, humility, these are not things always that our profession is known for. Although I think individual lawyers and judges have a tremendous commitment to access to justice. So I know forums are very, very dull, but I think it is helpful to see what a forum looks like if it's not designed by justice actors, if it is designed by regular people, even really vulnerable people. It looks simple. We also add in questions that are meant to respect people's human dignity. So we worked with LGBTQ+ advocates, so different community organizations, to add in questions about people's preferred pronouns and their preferred names so that we can make sure we're addressing people respectfully. We also ask people if they have difficulty reading or writing, if they have a visual or hearing impairment, a mental health issue, or any other circumstance that might make it difficult for them to participate. And then if they do tell us that they have one of these circumstances, we will contact them and figure out how we can accommodate them. And this also tends to really reassure people that they are welcome and that they are valued and that we will treat them with respect. Just lastly, one of the major things I think we've done to increase access for people is we've made it really easy for people with a low income to have their fees waived. So people with a low income don't have to pay fees, and that's true in our courts as well. The difference is that in our court system, we make people with a low income jump through about 20 hoops just to have a very small amount of money waived as their fee, just to not have to pay a court fee. We make them go and get tax information, go and get banking information. We make them line up at the court registry. We make them swear documents in front of a lawyer. We make them appear before a judge in open court, all just to have a couple of $100 of court fees waived or forgiven. So at the CRT, all we do is ask you to click a couple of buttons. You don't have to provide any documents. You can do this at the same time that you apply. Why? Because again, when you design with the public, community advocates tell us that it is very, very difficult for their clients when you put layers and layers and layers of administrative burden on top of people who are already really struggling. Another area where I think we've really tried to make sure that we are building equality and accessibility into the tribunal is through our Reconciliation Action Plan. As I know is the case in many countries in South America and around the world, we have a tragic and terrible history in terms of the way that we've treated our Indigenous people in Canada. And it's a history that we're only starting to come to terms with as a country. And one of the things that happened a few years ago is a Truth and Reconciliation Commission, a national study on the truth of the history of the way that we've treated Indigenous people, as well as some recommendations for the justice system, for lawyers, and for others in terms of how to reconcile with Indigenous people. That's something that we've treated really seriously at the CRT. And part of that has included creating a special position for an Indigenous law student. And that is in recognition of the fact that Indigenous people are underrepresented as judges, as lawyers, as policymakers, and as tribunal members. And our Indigenous law student position has been a huge success. We've also created a special role, a special position within the tribunal called our navigator, whose job it is to offer kind of a concierge service to Indigenous participants to support them throughout the process. This is part of a bigger reconciliation action plan that we're really committed to, and it has many dozens of action items on it. So all of that is really just how do we support people as they go through the process. I'll go through the rest of this very quickly, but parties have an opportunity to negotiate. We use a little bit of behavioral economics or nudge theory to try to encourage people to talk, but they don't have to. This part is voluntary. It's not voluntary, though, to participate in mediation. The mediation part is mandatory. And the reason it's mandatory is because we want people to come together in good faith and talk to each other. They don't have to reach an agreement, but they do have to participate. And the mediator will work with people through telephone, through text, through email, however the parties wish. And this has been really successful. And if the parties reach an agreement, that again can be turned into a court order. Last but not least, we have adjudication, which is the kind of trial or hearing phase. We have mainly full-time tribunal members. They're all lawyers who work remotely throughout the province. And most of the time, they look at the evidence electronically and the submissions, and they write their decision based on the written record. But they also do have training in holding Skype or Zoom hearings. This doesn't involve, though, just taking a regular hearing and putting it on Zoom, the way I said at the beginning. It involves having a careful approach that focuses on plain language, on explaining things to the parties, in speaking in a way that is informal and not stressful, in making sure that everybody feels comfortable with the process. I will just pause here also by saying that during the pandemic, what happened for us is we just kept on going. Most of the justice systems around the world closed down or only heard urgent matters, and that was true in Canada as well. We were really one of the only parts of the justice system that just kept on operating as usual. We are open 24 hours a day, 7 days a week. We have about 100 tribunal members and staff members. They all work remotely, so we just kept on doing that. And then in combination with the fact that we're really flexible about how we offer people our services, it meant that we could just keep going, people could keep using the CRT, and we could spend our time thinking about how best to help people. So for example, we created extra efforts at allowing people to extend their deadlines if they needed to, just as an example. But I think what made the CRT resilient in the face of the pandemic wasn't just the technology. It was the fact that the CRT, as I've been ranting about, was really co-designed with people who have vulnerability in mind. So we designed it thinking about people who have mobility problems, who couldn't leave the house, who needed childcare, who may have financial difficulty. And so all of this kind of vulnerability is reflected in all the different processes we had set up based on human-centered design. The technology was part of it, for sure. Being able to access systems online is very useful in a pandemic. But it's also that what's happening now is so many of us around the world have vulnerability as well. Many more of us are experiencing economic vulnerability. Many more of us can't leave our house. Many more of us are encountering health difficulties and other challenges. And so my point is that if you design a system in mind that is targeted to the most vulnerable people, that accounts for their needs, it will turn out to be much more resilient when those circumstances are affecting many, many more people in your community. So we got a lot of attention during the pandemic for staying open. That was largely attributed to being online. My point is, it's not just the online part, it's the human-centered design that allows you to be resilient and flexible in the face of an emergency. So I'll zoom by this. Our decisions, as I mentioned, are published. When the tribunal member finishes their decision, it gets emailed to the parties or mailed, depending on their preference. And in the same 24 hours is on our website and also in our national decision database. We also survey people who have gone through the process. We ask them what they think. This is not a common thing in Canada for courts or tribunals to do this, but we want to know how people experience the tribunal. This is part of human-centered design. And we also take the comments that we get and we use those to improve constantly. We take feedback from these comments, but also comments from our frontline staff, from anybody who is providing feedback, and we're constantly changing over and over and over and over again to get better and better, hopefully. So I'll just wrap up by saying something I said at the beginning, which is that online courts are not the solution to the access to justice problem. Technology is just one tool in this toolkit. It is tempting to create online buffers between our court system and citizens, but where that just excuses our court system from having to evolve and change and do the fundamental, difficult cultural and systems work to redesign from the ground up is not good enough. And so my pitch is that we shouldn't settle for that, that we should be, as justice actors, fighting for and instrumental in creating a bigger vision of the future of our justice system, one that is inclusive and accessible and equity-based. And a lot of the things that we've done to build the CRT with this goal in mind are offline. They are cultural. They're about training. They're about a worldview. They're about curiosity, humility, respect for human dignity. And I think that, way more than any technology platform, has been key to the success that we've had so far. So please take a look at our social media channels. That's one of the ways that we do public outreach. And I'm happy to answer any questions that you might have. And with that, I'll hand it back to Daniel. Thank you very much.
Oh no, thank you, Shannon, for such amazing presentation. Speaking about systems design, this is exactly what we talk about, how to create a justice administration system that really considers all the people that eventually interact with this system. I think that the main problem right now is that some governments, especially in Latin America, are confusing initiative for, let's say, improvement of the way the judges and the people that works in the justice administration work, in general terms speaking, how they do their day-to-day jobs, right? And they talk about blockchain and they talk about AI and a lot of things to help the judges and the people that work in the justice administration system. But that is not the conversation on how to create a better access to justice system, because a thing is to access the system, other thing is how the system works and behave and how the system is more efficient, etc. So in that regard, let me just start with this question. I think that for the last 3 years at least, we can see a lot of conversations going on around the world about how to fix the justice. Sometimes using tech, sometimes using innovation methods. But despite that, despite the conversations, sometimes I think that the hype around some things like, again, blockchain, AI, etc., on the justice administration system, justice systems around the world, and especially here in Latin America, are still the same pretty much, I think, everywhere, right? So what's happening? What is that? We have a lot of analysis and good ideas, but the system is not changing.
Yeah, I definitely have some thoughts about that. And I agree with you that that we should concentrate less on AI and blockchain and imagining what far-flung applications those might have on the justice sector. There's obviously a place for all of that innovation. It's happening already with a lot of legal tech startups. But to the extent that we use that as an excuse not to do the easy things, what we call the low-hanging fruit that you could do right now, it is just that. It's an excuse. It's fun to talk about robot judges. It's fun to talk about blockchain and evidence. What we could do right now to increase access to justice using human-centered design is as simple as judges and court administrators taking a clipboard and a pencil and walking out to the lineup in our court registry and talking to people, mapping how they got there, mapping how much money they spent, where they parked, if they took time off work, who's watching their children, who's helping them, have they hired a lawyer, how much does it cost them, how do they know they're in the right place, what are they trying to do, how many times have they come down there. You can have people fill out your forms and watch where they get confused or struggle. There are a million things we could do right now that require no technology at all that would radically improve our justice systems around the world. But it's hard. It's hard because it requires a big cultural shift, a real cultural shift away from the idea that we are the experts, we are the ones, we are the deciders, we're the ones who create the justice system, away from that idea and towards the idea that we should be approaching this like curious scientists. We should be asking questions, we should be thinking, we should be deferring to the experience of the people to whom the justice system belongs. So I think that you're right, a lot of those things could be red herrings. It's also a bit of an excuse, right? Well, that technology is not here yet, or it's not accessible yet, so we don't have to do anything. I also, a lot of the time, hear courts say, well, we don't have a budget. We don't have a budget for technology, and so we shouldn't do anything. Those are bad excuses for the reasons I've talked about, but also because there are examples now, too, of courts around the world who are using off-the-shelf technology to do everyday things. There's Judge Scott Schlegel in Louisiana, who is using doodle polls and Slack channels to be able to do court scheduling and make it easier for people to participate because they know what time they have to appear in court. These are little things, but it is an example of the kind of creative thinking that we can use to really change the justice system even when we don't have a lot of money. And when I was in Chile and Argentina, that was the thing I heard a lot. Governments are under pressure financially. There isn't a lot of money in the justice system. And so we need to think creatively about what we can do with what we have. And I think there's a lot. The good news is if there's a will, if there's an interest, there's a lot we can do. We can write at a grade 7 reading level, or like the reading level of an average 10-year-old. We can train our staff in mental health issues. We can have interpretive services, drawing even on the resources that we have internally within our staff. There's a lot we can do. It's a very long answer to your question. I promise I'll keep it shorter.
No, that was great. That was great. Jimena Guevara is asking, how long did it take to make this transition? I guess in that when she says transition is that before CRT, people uses the justice administration system in the regular way, even for these small claims. But after CRT, how long did it take to do people start to realize that they can use a better system as the one that you lead, Shannon, in order to solve their problems?
Yeah, there was definitely a big public education part of this. I spoke at community centers, really anybody who invited me to speak, I would come and speak. We also did a lot of work with stakeholders to make sure they had information to give their clients. We worked with things like Google Ads to let people know if they were Googling their problem, we would come up. So we wanted to make sure we were catching people before they went down to the courthouse and found they were at the wrong place. Overall, that's been pretty seamless, I think. We've been lucky in that regard. But it is a constant part of this. How do you educate the public about what their legal rights are? That's part of a bigger challenge that we have as a society, that people don't know where to go to solve their problem. Oftentimes, they don't even know it's a legal problem. They just know they have a problem. And so that's one of the areas where the more we do outreach, the more we get out there, the more we can try and catch people and let them know that this is an option. Another big source for that is that because our decisions are written at about a 10-year-old reading level, that's often the newspaper's reading level as well. And so often the decisions we write will be the subject of news stories. Because they're interesting fact patterns or people report on them, which is really good for transparency, but it's also really good for getting the word out about the tribunal as well.
Great. Let me just see another question here. Celeste Farfan, she says that she understands that the CRT is working pretty well for civil and commercial small claims, right? But she's asking if you're considering right now to maybe extend the scope of the type of claims that people can use the CRT in order to get solved. For example, labor law issues, family or sort of kind of issues like that.
That's a good question. So it's the government here in British Columbia that decides whether or how to expand the CRT's jurisdiction. So we are not meant to have opinions about that. We take whatever jurisdiction we're given. That said, it is pretty broad. I mean, starting with neighbor disputes and then small claims and then car accidents. Also, we have jurisdiction over nonprofit organizations. And I think it's an area of a lot of potential, particularly with family cases. Family cases, at least in British Columbia, tend to be very adversarial. The parties are angry, they're emotional, and putting the court system, an adversarial court system on top of that, causes them to spend a lot of money, often make their problems worse, and not always act in a way that's in the best interest of kids. And so to the extent that you can use more relaxed, informal, plain language, inexpensive, collaborative process, that seems to have a lot of potential. There are no plans in British Columbia to do that as far as I know, but I know in other parts of the world, online dispute resolution is being used in family cases. That's true in Nevada and other places. So I think there's huge potential there. I think the key message though is the CRT exactly maybe wouldn't work for every case in the world, but I think the approach could work, which is to say that even in a criminal case, it would likely be to everybody's benefit to map the process from the perspective of the accused person, of the victims, of the prosecutor, of every actor in that process, and figure out how we can add humanity and equality and accessibility and human dignity to that process. A lot of the things that we do in criminal process, we've done it that way for hundreds of years, not always a lot of good evidence for that to support it. So I would take the same approach in all areas of law to the extent that it means thinking critically about why we do things, figuring out how we can design the system to be more equitable and accessible, and to approach it with a lot of curiosity as well. And I think that approach will lead you in lots of different directions. This is just one direction.
Right. Yeah, I mean, that's exactly the same thing that sometimes I say when people ask me if, for example, legal design methods and techniques are like widely available and can be used for all things in law. For example, apply legal design thinking and tools to an ASP, right? A huge contract in order to try to materialize an acquisition of companies. Maybe no, maybe the legal design tools in this kind of things are not the ones, but how can you think using legal design thinking methods is the important thing here? It is exactly thing that you were saying previously with how the CRT work and how eventually the CRT system and way of thinking the law can be applied to other jurisdictions as well, right? So thank you again, Shannon. I'm just come back with Jose María to close the event.
Thank you.
María, regresamos contigo.
It was really inspiring hearing you. Thank you so much, Daniel. Bueno, entonces ya estamos llegando al final del segundo día. Realmente qué lujo haber tenido estos panelistas. En el mundo prepandemia, para quienes recién están emprendiendo el mundo, el camino al emprendimiento legal, les cuento, ir a una conferencia, un foro donde estuvieran Daniel Acevedo, Shannon Salter, Kate Moon, no sé, podría costar $500, $600. Me parece realmente increíble que podamos haber reunido a estas personas para conversar un poco con ustedes sobre esto. Mañana ya tenemos nuestro último día, el tercer día, agradeciendo mucho a los expositores y a ustedes por estar conectados. Les recuerdo que la discusión mañana comienza más temprano, a las 5 de la tarde, porque vamos a tener una discusión justamente sobre cómo los estudiantes pueden aprovechar y montarse en la ola de innovación legal, y justamente unos estudiantes de la Universidad del Pacífico van a contarnos de algunos de sus emprendimientos. Finalmente, les recuerdo que la discusión no termina cuando se apagan nuestras cámaras. En LinkedIn, en Facebook, en Twitter podemos utilizar el hashtag Abogados del Futuro para seguir conversando. Muchísimas gracias.